Welcome everyone to AI in Legal Practice, Trends, Trust, and Talent, presented by Microsoft and Korn Ferry and vLex. We're excited today to spend the next 90 minutes with you with a number of wonderful presenters. And with that, I will hand it off to my colleague, Simona Fitzgerald. Simona?
Thank you, Grant. Good morning and welcome, everyone. I'm Simona Fitzgerald, and along with Grant, we are your Microsoft moderators for today's session. Look, we stand at a moment of transformation where law and technology converge and legal leaders help set the standards for ethical AI. Today is about understanding that shift. So we brought together some of the most forward-thinking voices in law, technology, and talent development, leaders who are actively shaping the future of AI. At Microsoft, we call these frontier firms, organizations at the leading edge of innovations that combine human judgment with AI to scale faster, work smarter, and unlock new value, all with an AI-first mindset. In today's agenda, we'll explore how AI is influencing legal decisions, compliance, and operation. You will also see a live demo on Microsoft Researcher Agent in Copilot, showing how AI can make a legal work faster and more secure. Quick housekeeping note, we will be moderating the Q&A, so please share your questions. We will also have your Microsoft account team follow-ups for any questions that we might not be able to answer today. With that, it is my pleasure to introduce Brian Willson, Microsoft Vice President of Professional Services Industry. Brian, the floor is yours.
Thanks, Simona. I'll just add my welcome to everybody. Thank you for taking the time, investing your time for today. I'm excited about today's session. We know your schedules are demanding and we have high quality content to go through. So I'll add my welcome to this AI and Legal Practice, Trends, Trust, and Talent. And this summit brings together technologists, corporate counsel, regulators, and C-suite leaders to explore the most pressing questions in the profession. How do we harness AI responsibly while also strengthening trust and talent strategies? We're going to focus on three key dimensions today: the trends reshaping legal workflows and governance, the trust that underpins privilege and compliance, and the talent strategies defining the new lawyer in an AI-driven world. You'll hear from thought leaders at Korn Ferry, Microsoft, vLex, who will share their own AI journey and insights on talent strategy and readiness. And then, as Simona mentioned a little bit earlier, we're also going to show a cool demo on Researcher Agent and Copilot to help aid in acceleration of legal research with precision and security. So whether your role centers on compliance, operations, or leadership, today's session is about equipping you with actionable ideas to lead confidently in this evolving landscape. And now it's my pleasure to introduce our keynote speaker, Damien Riehl. Damien is both a lawyer and a technologist, a rare combination that brings incredible perspective to today's discussion. He's been practicing law since 2002 and coding since 1985. Over the years, Damien has clerked for chief judges in state and federal courts, spent more than a decade in complex litigation, led global cybersecurity and digital forensics investigations, and built AI-powered legal software. Damien, welcome. The floor is yours.
Thanks so much. I'm really thrilled to be here, and thank you to Microsoft for joining us all here today. I speak quickly, so buckle up. So we are really on an amazing time with our large language model news. Of course, everyone has been abuzz about large language models, and what LLMs are matter, but they matter less to you than what I'm about to show you. That in December of 22, GPT 3.5 beat about 10% of humans on the bar exam, which is not nearly as impressive as GPT-4 in March of 23, beating 90% of humans on the bar exam. That's worth repeating. GPT-4 beat 90% of humans on the bar exam. And a lot of lawyers said, that's fine because the practice of law is not the bar exam. And I agree with them. But the question is how much of what we lawyers do every day and that we bill our clients for every day is actually far easier than the bar exam. So this is why everyone is talking about large language models in the context of the law. This is human performance. And even back in 2023, LLMs beat us in reading comprehension, in language understanding, and predictive reasoning. You know, lawyer things. And in 2017, GPT-2 was about a preschooler level. GPT-3 was about elementary school level. GPT-4 was a high school level. And o1 beat PhDs in physics. O3 beat the ARC Artificial General Intelligence Prize that we didn't think was going to be beat until 2040. So as we go forward, the question is, where is each of us on this line? Are we PhDs in physics? And the question is, how much before large language models beat us in all of those areas? This is the ARC AGI prize I mentioned earlier. Experts thought that maybe they'd beat 50% of humans come 2039, but it didn't take until 2039. It actually just took a few months, and now it's already beat even the best of us in this ARC AGI prize. So DeepSeek, which is a model out of China, is free and open source. You can download it and run it on your laptop. Is pretty close to that ARC AGI prize. This is human PhDs in their field with a graduate level Google proof Q&A. This is stuff that you can't Google, that PhDs take a while to be able to answer. And you can see back in June of 23, it did poorly. And it was beat in March of 25. And now you can see it's actually gone much farther. So not only has the large language models beat the human PhDs in their field, look at the cost. Back in June of 23, it cost $50 per million tokens. Now it costs 50 cents per million tokens. That's a decrease of 99.4%. So at the time that intelligence is rapidly increasing exponentially, the cost is rapidly decreasing exponentially. And what are we going to do with this as human lawyers? This is a study out of September of 23 where human evaluators judged usefulness of an output and reliable of an output. They did a double-blind study between human lawyers, ChatGPT, Gemini, Copilot, and Claude. And you can see all of these that some of the models beat human lawyers that were both more reliable and more useful than others. And of course, I wager that Copilot is going to exceed these very soon. So when we think about where AI is in this, the question is how much between the lowest IQ of humans and the highest IQ of humans, there's a bell curve. And now substitute humans for lawyers. The question is how long before the large language models, including Copilot, exceed even the best of us? And how long before not using these tools is malpractice? And how much of the legal work requires this highest IQ versus paralegal work versus first-year associate work versus fifth-year associate work versus junior partner work? This guy thinks that maybe we should use this power to help the poor, people who can't afford a lawyer. Maybe answer basic questions, maybe smooth out the mismatch between the urgent needs and lawyers that are available. And I don't agree with him on all of the things, but I certainly agree with him on this. If we're not, 92% of legal needs are unmet because we lawyers are too expensive. If you're not ashamed of that, perhaps we should be. And we should be using these tools like Copilot offers to be able to maybe smooth out the mismatch. There are a lot of tech companies, mine's among these. The reason for that is everything that we do as lawyers involves words. We ingest words, analyze words, and we output words. And large language models can do that at superhuman speed and at a postgraduate level. And so what I'm going to be talking about today is what litigants today are using, both lawyers as litigants, as well as self-represented litigants who you might be on the other side of the V from. And also decision makers, that is courts and arbitrators, are also using these large language models. So these are ways that, really all three sides of the V, plaintiffs, defendants, and the courts, are all using a triangle large language models. And they're using them as tools. That is, AI is a tool that solves problems, but we shouldn't be thinking of them in that order. We should be saying, what are the problems we want to solve? What are the tools to solve those problems? And it turns out that AI is a really good tool to solve those problems. I want AI to blank. What is the blank? Whatever that is a problem. And then AI can maybe solve that problem, including Copilot. So one thing that I, as a litigator, when I litigated for Robbins Kaplan, one problem I wanted to solve was to create counterarguments and good facts. So I took an actual lawsuit where it was a lawsuit over ingestion of code. And this is a breach of contract lawsuit. And so I said, here's a motion to dismiss, create a list of counterarguments. And here is a list of counterarguments where they said they lack standing. They said, no, these are concrete injuries. And for each claim, what are the elements? It gave me actual non-hallucinated elements of those claims. And then I said, give me facts that can prove each element. Do that for every claim. And here's the facts that prove the element for every single claim. Injury in fact, yes. Causation, yes. Redressability, yes. I said, now show me that they lost a big client. And here's injury in fact, causation, redressability. I said, now create questions that will help the client win. And here is a bunch of questions that will help the client win. Causation. Show me the time that it began using the code. Everything here took me less than 1 minute. So the question is, how long would that have taken an associate? And if the associate charges $500 per hour, maybe 8 hours, how are you going to charge for 45 seconds worth of prompting? And what if you don't have to be a prompt engineer? What if you have access to 1 billion legal documents, all the cases, all the statutes, all the regulations, all the motions, briefs, pleadings? And what if you don't have to be a prompt engineer? You simply upload the motion and it gives you all of this, no prompting necessary. Or maybe the filing happens, the motion gets filed, and before you even know it's filed, we do this in the background. And we send you and your clients this 200-page memo that maybe gives good responses to that motion. We've talked about the death of the billable hour for decades, and I don't think the billable hour is going to go away, but I think as a percentage of revenue for the firms, I think the percentage of revenue, 90% billable hour and 10% flat fee, that 10% flat fee is probably going to raise to 20 to 30 to 50 to maybe hover around the 60% flat fee that the big four accounting firms generally charge. They've essentially systematized enough of the work that 60% is flat fee, but about 40% is still hourly. And I think maybe a reasonable future would be that we as lawyers would have that maybe 40% hourly and 60% flat fee. So I think the death of the billable hour is a misnomer. We should just be saying what percentage of revenue is the billable hour. Another problem I wanted to solve, I want to find logical inconsistencies in an argument. And here's an argument with logical inconsistencies. And they said, hey, you didn't have legal interest in restricting the study of this code. And the response from the client would be that, hey, by making the code available, they didn't relinquish legal interest. They included terms and conditions. That is a good legal argument. Another argument is that you didn't say which of the entities were part of this litigation. A response is, listen, these are joint actions with the same corporate family. We can further refine through discovery, but at the motion to dismiss stage, it's premature. This one still blows my mind. It said that you could argue that the injury in fact was the breach of contract itself, because it was at that point that the coders lost control over the code that they intended to retain. This is a really good argument that I litigated for about 15 years, and I wish I could say I thought of this argument, but I'm sad to say that I don't think I would have. In fact, this is such a good argument that I thought, was it hallucinated? Was it made up? So I went to the tool that I'm building, Vincent, and I said, can a breach of contract itself constitute the injury in fact? And it brought up actual non-hallucinated cases, saying, yeah, a breach of contract itself can be injury in fact under Article 3. But I didn't stop there. I went to the underlying cases and the text of there. And, this is where people say, well, I don't use it because it hallucinates cases. Well, if you have the cases, then it won't hallucinate. That you'll actually have the actual non-hallucinated text from actual non-hallucinated cases. There's a solution to hallucinated cases, and it's called read the cases. Another case, Patel, cited a bunch of other cases saying that, yes, breach of contract can confer Article 3 standing. So most importantly, the large language model here was an ideation machine. It gave me an argument that I wouldn't have had before. And it didn't just give me one argument, it gave me many arguments. And if you have the actual non-hallucinated cases, statutes, and regulations, then you have the ground truth to be able to cite to a court, or to cite to a regulator, or to cite to opposing counsel. You need that ground truth. This is called retrieval augmented generation. Have the ground truth to be able to make good arguments. I said, people that say, well, large language models aren't very good because I used it once and it didn't work. And I would say that don't stop at question number one. Try again. Here I said, I love the fact that you said injury in fact can constitute Article 3 injury. Tell me more. Expand upon this. And I said, yeah, a lot of these large language model, a lot of these code snippets, licenses require attribution to the original coders. And a lot of the licensing prohibits commercial usage. These are good factual arguments. And had I not asked question number 2, I would have never received it. So if at first you don't succeed, prompt again. With contracts, here is a merger agreement. And there is now an ability to be able to say, here's a bunch of clauses that you might want to look at. Maybe you want to negotiate differently. suggest language that's more aligned with my client's interest, making it more seller-friendly or more buyer-friendly. Maybe the terms that are ambiguous, disambiguate those terms. What is fair market value? Well, if the stock goes up and down, at what day is the fair market value? What are my post-closing obligations? Go through 300 pages and find the post-closing obligations. What should my client be worried about? One of my law school professors said, if you want to understand a statute, put it into if-then statements. If this thing happens, then this would be the output. So I took a random statute, happens to be New York statute for falsifying business records, and I said, summarize the statute, put it into if-then statements. And here's the output. If someone falsifies business records and intends to commit or aid and conceal another crime, then Class E felony. Now look at the text on the left and look at the text on the right. I'm going to ask you 3 questions. Question number 1, which is easier for you as a lawyer to understand? Question number 2, which is easier for your clients to understand? And question number 3, which do you think is easier for a computer to understand? Because computers work in if-then statements. So what if you hypothetically had access to 1 billion legal documents, all the statutes, all the regulations, not just in the US, but 100 countries worldwide? And what if you were to put all of these statutes and regulations into if-then statements? We're on our way to computable law. I said, now argue violation of this statute. And it goes through the facts to be able to show what you would need to prove to show a violation of that statute. Now I'm a copyright lawyer, and greetings from Minneapolis. And I said, when will Purple Rain be in the public domain? But I didn't start from 0. I started from the copyright statute that relates to duration of copyright. This is called retrieval augmented generation. So if you start with the statute and then you ask about facts as applied to that statute, the rate of hallucination is less than humans. That is, he died on April of 2016. The statute says life of the author plus 70. 2016 plus 70 equals 28, but the statute also says that it runs to the end of the calendar year. So it doesn't actually enter the public domain until January 1 of 2087. That is the correct legal answer. Now, if you're a copyright client, option number 1 is to ask your friendly copyright lawyer. Option 2 is to bypass your copyright lawyer and just go to something like Copilot. That option 1 lawyer is never going to know why the phone stopped ringing. Next, I said, how about What a Wonderful World? Nothing more than that. And they said, well, these are joint co-authors. And the statute says joint works go by the last surviving author plus 70. Last guy died in 2010. 2010 plus 70 equals 2080. But again, it doesn't end at 2080. It actually goes to January 1 of 2081. That is the correct legal answer. This is a reasoning machine. Large language models like Copilot are able to reason, and increasingly well. A friend of mine is a privacy lawyer, and she said, you'll never be able to do a privacy playbook like I do with my clients. So we sat downstairs in my kitchen, and I said, you represent a retailer, build a privacy playbook under California law. And here's the output, saying things like, why are you processing, receiving, who's receiving that data? Are you minimizing data? Are you dealing with GDPR? As a data subject, can I access, delete, opt out, non-discrimination? These are all things she said that she would do on day 1. And then on day 3, she would go on to be able to say, hey, how are you using this data? Are you collecting names and addresses for loyalty programs? Are you collecting purchase history for marketing? Are you collecting web browsing data to be able to personalize content? She said these would all be like week 3 kind of assessments. If you want to be able to take an interview and turn it into a litigation complaint, here's an interview, and turn it into a complaint. Put those in the facts and the claim sections. And here's the output. And this is not something that I would file with the court right away, but it's way better than a first-year associate. Defendants, Microsoft had, or I'm sorry, not McDonald's had a history of serving hot food, unsafe and unnecessarily high. Here's the bad things that happen to my clients. Plaintiffs' lawyers are jumping on this because when plaintiffs' lawyers shrink their costs, they increase their profit margins. So they are using this left and right. If you're a jury consultant, I'd be worried. Give me a bunch of questions saying, do you know anything about large language models? Can you explain your understanding? Do you think that people should be able to have close family members and friends? Do you think that if you have a close family member, that might taint their view of coders? Do you think companies have exclusive rights to their code? If you're representing the coders, a good answer is you need to protect their work, and bad answer is no, information should be free. If you're a coding lawyer, you want that person to get off the jury. We create decision trees, whether they're implicit or explicit. And here's a decision tree. And you can see number one, it goes through the elements of breach of contract. Was there a contract? Was it breached? Was there damages, etc.? But look at number 6. Client, have you tried to negotiate? If not, you might want to consider that. And number 9, listen, I'm expensive. Is the amount in dispute worth justifying my cost? This is a good decision tree that not only goes through the elements of breach of contract, but 6 through 9 talk about the practical considerations of what you need to do. Create a chronology. Who did what when? You could be able to input into Copilot or anything else, any number of corpus, and it could be able to sort it into dates, facts, and people. A lot of people say the large language models are only able to look backward. They can't actually look forward. And for that, I give an actual anecdote about a friend of mine who works in-house for an insurance company. And she said, Damien, what do you know about effective computing? And I said, I actually don't know what that is. So let's jam with the machine. And it turns out effective computing is how computers recognize human emotions like facial expressions and voice patterns to create emotionally aware agents. I said, cool. Now, how can that be used by an insurance call center? And that's how my friend's company was thinking about using it. And they said, well, you could use it for emotional recognition of the callers to see if they're highly emotional because of their accident. And I said, cool. Now give me a list of the legal issues, issue spotting. And they said, have you thought about privacy law, GDPR and CCPA? Have you thought about whether your customers gave you consent to analyze their emotions? What if you get hacked? What if all the emotional data is in the hacker's hands? This is really good issue spotting. And I would say that never before in the corpus of training data has anyone asked about legal implications for effective computing. That's not anywhere in the corpus of training data. But what large language models do is they connect disparate concepts in what's called latent space. And on the left-hand side is something called effective computing. And the right-hand side is something called legal issues. And what the large language model did here, what Copilot can do, is to connect those two disparate concepts in ways that have never been in the training data. Connect effective computing and legal issues and be able to put them together. This is what this connection of disparate systems and disparate ideas is what a lot of people will call creativity. And you could imagine saying, give me 100 more legal issues. Give me 1,000 more legal issues. And large language models like Copilot would explore that latent space. So really, you could just collect use cases. A friend of mine has a Post-it on his monitor and says, can AI help with this? And the answer almost always is yes. Everything a lawyer does is ingesting words, analyzing words, and outputting words. And it turns out that AI does that at a superhuman speed and at a postgraduate level. So what can AI not do? Well, it can't tell you what your odds of winning this type of motion for this case type in this court, maybe before this judge. The answer to pretty much from every lawyer is saying, well, the odds are pretty good or not bad. Oh, what if you were to say, well, the odds for winning summary judgment in all the courts are 54%, but in this court, the odds drop to 45%. But for this judge, it actually goes up to 56%. But for trademark cases, the odds are about 1 in 3. Now, if you're a client that's thinking about bringing this summary judgment motion and maybe spending $100,000 in legal fees, do you want to know pretty good or not bad? Would you like to know that this trademark likelihood of winning is about 1 in 3? So this is obviously better for the client, but it's also better for the lawyer. Because if you don't know these odds, and if you say, hey, I think our odds are pretty good, let's spend $100,000, and if you're probably going to lose because 63% of them lose, then the client's going to think one of two things. Either one, Damien lied to you, right? It wasn't actually good odds of winning, and he just wanted to screw me out of money, right? That's option one. Option two is also a bad option because they could say, yeah, the odds were pretty good, and Damien lost. Therefore, Damien's kind of a bad lawyer. So wouldn't it be better to say, hey, our odds are about 37%, but let's give it a shot. Let's go forward. And then when we lose, like we're probably going to lose because 67% of them lose, then the client will say, hey, we knew it was short odds going in. Let's go forward. So this is a way you can build trust with your clients. And then what if you want to go from analytics mode to research mode to be able to say, I want Susan Richard Nelson to grant my motion. So what if you could say, show me winning motions like mine for this case type in this court before this judge? And here's the output. Here's Susan Richard Nelson's summary judgment motions where she's granted. Your Honor, this is just like the case you decided last year. Or Your Honor, this is just like the case you decided yesterday. Then what if you want to draft a new motion that is statistically likely to win for this claim in this court, maybe even for this judge. That is, what if you took all of Susan Richard Nelson's motions that she's granted, and then put that text into a large language model like Copilot or others, and be able to say, now here are my new facts. Give me arguments that are statistically likely to win in this jurisdiction for this cause of action, maybe for this judge. This is the reason I left the practice of law in 2015, because I thought someday we're going to be able to draft this statistically likely motion to win. And it took 10 years, but here we are. And what if you bake all this into legal software so you don't have to be a prompt engineer like I am? And this is why I left in 2015. And I'm building a tool that now you can upload a complaint. And it'll say, here are all the claims, here are the facts, here are the parties involved, here is summarizing relief that I'm seeking. And these are all extractive. And then here we also say, what are legal defenses to mount for each claim? If I'm Microsoft, how do I respond to this lawsuit? How do I respond? How do I ask my clients questions to help them win? Vincent gives you all these, no prompting necessary, and then gives you legal research questions based on non-hallucinated cases, statutes, and regs to be able to do this too. By the way, everything you see here is running on Azure's backend. We are using Microsoft tools to be able to serve up the things that you see on your screen right here. But the point is, you don't have to be a prompt engineer. You simply upload the PDF, and it gives you 200 pages worth of analysis, including analysis of each of the claims, facts related to each claims, and also defenses for those claims, fair use, purpose and character of the use, training the AI models, which is fundamentally different than the original publication. And AI-driven insights don't replace the original journalistic function. These are good arguments. And we give these to you, no prompting necessary. Hey, tell me about the questions for my client to help them win. What was your training data? What were your sources? You could do the same thing for contracts. If you upload a contract, we'll give you different buttons. Again, no prompting necessary. And these are things that contract lawyers care about, like fallback positions, client hostile language, strategy, etc. And now here's a way that you could be able to go forward and be able to do things that people have been using these tools, like I've just showed you, for years now, and it's just not evenly distributed. So when you talk, this is not just being used by law firms, this is also being used by corporate law departments, in-house counsel. I speak to a lot of them. And these are actual statements saying, you know, this is like having a really smart colleague sitting right next to me. And it doesn't do things I couldn't do, but it does things I wouldn't do because I didn't have time to do it in the old world. I use this every time, multiple times a day. Things that I would have called my lawyer about, I say, oh, can this tool do it? And it actually gives me a really good answer. And I don't have to call my lawyer. This lawyer doesn't know why the phone stopped ringing. So when you think about your business model, the whole leverage model of associates, maybe that is going to decrease in importance because you can get 200 pages of analysis as a law firm, no prompting necessary, but also the client, the in-house counsel, can also get 200 pages of analysis, no prompting necessary. And so the question is, what is a law firm externally? What value do they provide that the in-house counsel can't do already with these 200 pages? So one thing that Salesforce, which is to a company that used my tool, there's one of the leaders said, this is amazing because this gives me kind of week 3 insights as to litigation strategy and defenses and that kind of thing. And he said that these would take me, a law firm 3 weeks to get this, but I don't have to wait 3 weeks. I get this on day 1. So this allows expedited analysis of litigation, contracts, etc. And so as a law firm, you have to say, okay, what am I doing on top of what the machine gave the in-house counsel right away? And this is something that everyone is thinking a lot about and thinking about their business models. And if they now have 3 weeks worth of work in 5 minutes, do they have to defer to external counsel? Because in the past you did, because external counsel did the work. But in-house counsel, law departments, if they have that work on day 1, they can say, well, external counsel, you're suggesting this defense, but look on page 200. That's offset by this case that finds against you. And a case for patent drafting, they look to save $2 million in year 1. They actually exceeded that. I stood on stage with Salesforce at ILTACon, and they said in the first 6 months of this year, they've already saved $3 million from external spend that they brought in-house. So they saved $3 million in the first 6 months. They're anticipating about $6 million by the end of the year. That's $6 million that they would have spent on lawyers, but they're just using tools backed with Azure and others to be able to get this thing done. So these stories are everywhere. And again, the lawyers externally don't know why the phone stopped ringing. So a lot of people object saying hallucinations. And I would say that that's the biggest reason that people don't use AI. They say, I don't trust it. But the real question is compared to whom? And if you think about this is a study from 2023 saying they said, hey, humans, summarize this document. And then they had the machine summarize the document. They mixed them up, gave them to human reviewers. And the reviewers say that the humans hallucinated more often than the machines. That is, the humans got facts wrong more often than the machines did. By the way, that was back in 23. The machines have gotten much better at hallucinations since then. And how much better have the humans gotten? This is another one talking about analysis of, excuse me, human experts. And again, exceeded us in reasoning and in understanding. That was in August of this year. Here's another one with medical experts saying that LLMs are either equivalent or superior to medical experts in summarization. And human-generated summaries have more fabricated errors than the machines. So the real question is, compared to what? Is a large language model already more accurate than the humans that you hire? And maybe they are. And this is the reason any hallucinations happen is because of what John Dean realized at Watergate, that before he knew they were tapes, he testified in front of Congress. And he got a lot of things wrong, like who said what, but he got the gist of things directionally right. And the reason for that is something we as psychologists have known for years, is that we don't actually access our memories like a database, but we actually reconstitute them. We regenerate the memories. And that's the reason that the fish starts as this big, and then it gets this big, and then it gets this big. That's because we're regenerating that memory every single time. But that's kind of like what large language models do. They're not accessing database. They're regenerating what they got from their training corpus every single time. And so this is much like if you would ask Noam Chomsky, one of the best linguists of the 20th century, say, hey, tell me about the book that you wrote in the 1960s. He's going to get a lot of things wrong, because he's just basing on his memory, and he's reconstituting his memory of what he wrote in the 1960s. But if you were to instead say, hey, Noam, here are 3 pages from that book that you wrote in the 1960s, he's going to get those right. And the reason he's going to get it right is because the document is right in front of him. So his rate of hallucination is going to be much, much lower. Let's treat our large language models the same. Between saying, hey, out of the entire internet, give me an answer, it's going to hallucinate. But if you say, here's the particular cases, statutes, regulations, my client's facts, analyze the facts to the law, the precision is going to be much, much higher. LLMs out of the box are not fact machines. They're not search engines. They analyze content. And if you give them the cases, the statutes, and the regulations, yesterday's case, and whether that case is good law, it's going to be much better than humans. So this is to be able to say, don't give them a closed book exam. Give them an open book exam. Because just like humans, the rate of hallucination is going to be much less with open book exams. This is called retrieval augmented generation. We should be doing this every single day. We should be giving it non-hallucinated cases and non-hallucinated text. And this text that you see here is non-hallucinated 100% of the time. Not 90, not 95. It's 100% of the time non-hallucinated text, and 100% of the time non-hallucinated cases. And you might say, well, Damien, how can you say 100% and not 99%? Because I've heard about large language models. And I can say 100% non-hallucinated because this text wasn't created by a large language model. This text is a database search, like we've been doing database searches for 40 years. So if you have ground truth text from ground truth cases, then the rate of hallucination of summarizations of how well that text answers your question, that rate of hallucination is going to be less than the associates, or maybe even less than the partners. So the A in retrieval augmented generation matters. Because if you were to ask a lawyer, what's the average case length of civil rights cases that settle in the central district, how would most lawyers answer that? Or could most lawyers answer that? Because settling is a hard thing to determine. How do you even see if it's been settled? But if you have the data, that is, if you have the central district court cases that are civil rights cases, and if you have the file date and the terminated date, And if you have the fact that a stipulation to dismiss the case usually means that the case has been settled, if you have that data, a large language model like Copilot could be able to reason and be able to say, okay, of the 25 civil rights cases, some settle in as little as 12 days, but most of them take about a year and a half. Ask this of a large language model out of the box, and it's going to hallucinate all over the place. But if you have the structured data for the large language model to reason with, then, of course, the rate of hallucination is going to be probably less than humans. So a lot of people say, well, I don't trust it because it's a black box. We don't know how it works. And to that, a friend of mine is a nurse anesthetist, and she said something about anesthesia that freaked me out. Maybe it'll freak you out too. She said, do you realize that we have no idea how anesthesia works? I said, wait, what do you mean? She said, yeah, it could be one of two things. Either it's one, what everybody thinks, where it puts us to sleep, the knife goes in, and we don't feel a thing, right? That's what everybody thinks. Or it's option number two, the knife goes in, we feel every single cut, but the anesthesia makes us forget. Now, that freaks me out. Maybe it freaks you out too. But the real question is, do we still use anesthesia, even though we don't know how it works? And the question is anesthesia helpful? And if so, then how it works matters less. So maybe we should be looking at large language models in the same way. Is the output helpful or not helpful? And this takes us to what's called the duck test. A friend of mine from MIT said that machine learning experts use the duck test. They have inputs into the machine. The machine is a black box. They don't know how the machine works, but they gauge it based on what's the output. And if the output looks like reasoning, quacks like reasoning, then maybe it's good enough to be reasoning. That is, maybe it doesn't matter what's in that black box. And really, that's how we as humans judge other humans. Because every single person on this meeting, I can't see what's going on in your brain. Your brain, to me, is a black box. But if what comes out of your mouth and what comes out of your keyboard looks like reasoning and quacks like reasoning, then I judge you that you're reasoning. And so maybe we should judge our large language models in the same way. This guy knows a thing or two about revolutions. And he oversaw and pushed a revolution about saying that, hey, with PCs, you had zero marginal cost to duplicate things. And then in the 2000s, you had zero marginal cost to distribute things, emails, and to be able to do commerce. But today, there is zero marginal cost to be able to generate things. That is to ideate, to create documents, to duplicate, to distribute. These generation now is a new revolution that Microsoft is helping lead through Copilot, Azure, and other initiatives. And so really, how much of what we do as lawyers is ideation, creative legal solutions based on documents, cases, statutes, regulations, former precedents of contracts. This is an exciting time for law because really we can do things manually, but the machines are often more accurate than we are. And people that say, I don't believe you, say, no, there's empirical proof. I went through some of it. And really, is every lawyer above average? Or really are the machines going to be blowing by us? Because the last thing I'll talk about is that there's a contract review study where humans were 93% accurate for a contract review and machines were more accurate than the humans. Humans took 200 minutes, machines took 4. And the cost per document went from 76 for the humans versus $1.25 for the docs. So already, and this study was from 2023, the machines were already 300 times cheaper than the humans. And the machines have gotten much, much better since 2023. Copilots gotten much, much better since 2023. How much better have humans gotten? Writing is thinking. Stuff that makes sense in our brain doesn't make as much sense on paper. But really, how much of our thinking is original thought? Because we're all looking at the cases, statutes, and regulations that came before us. And if I tell the judge, hey, I've got this new idea, she'll say, show me the case. And I say, no, judge, there isn't. This is an original thought. I usually lose. And so really, when you think about how many thoughts you could have in a given hour, maybe 3 or 4, in that same time, Copilot and others could be able to have 1,000 thoughts. And then you can curate. And if it's based on the cases, statutes, and regs, you can trust those ideas. And then you curate the top 3, 5, 10. And the 3 or 4 that you had, really you're just recreating the wheel from the cases, statutes, and regulations. So I would encourage you to, as you think about what we're going to be doing going forward in the next 2, 3, 5, 10 years, it's not going to be humans or machines. It's going to be humans plus machines, like Copilot. being able to do things faster, better, stronger than we as humans alone could do, or that the machines can do alone. Because we as human lawyers have a lot of things stuck in our brains that the machines don't yet have. What happens in the closed door negotiations? What happens does this judge hate it when you do this? Does this, with an M&A deal, this is what makes the deal go south. Those are all things that are stuck in lawyers' brains that are not yet in the corpus of data. And that's how we're really going to be focusing going forward. What is the reason people are hiring you? It's for your insights in your brains. And things like Copilot will be able to help you work with those insights faster, better, stronger. Thank you very much for your time and attention.
Thank you so much, Damien. That was outstanding. I'm going to pass it over now to my colleagues Maha and Farah, who will provide us with an overview and demo of the researcher agent in Microsoft 365 Copilot.
I will start us off with our introductions. Hi, my name is Maha Farah, Senior Corporate Counsel in the Experiences and Devices Legal Team at Microsoft. I help Microsoft 365 engineering teams navigate complex legal issues. And I have here with me Farah Ali. Farah, if you want to come off mute and introduce yourself.
Sure. So my name is Farah Ali, and I work with Maha also on supporting a lot of the Agentic Copilot, including researcher, and we're excited to be here today.
So Microsoft 365 Researcher is built right into Copilot. It's available everywhere you work. No extra tools or setup is required. It's designed to make complex research easier by helping you quickly analyze text, summarize long and detailed documents. This tool, in my opinion, doesn't just save time, but it ensures accuracy by leveraging your organization's enterprise data securely and responsibly. When you start using it, you will notice that it takes a bit longer than your average Copilot to respond to your queries, and that is because it performs a very deep reasoning over the content that you provided. So for me, it is perfect to prepare for client meetings, rewrite legalese into a business-friendly voice, perform an initial research, or analyze content. I do have to admit, I have used it to help me understand complex technical issues as well in the voice of a 4-year-old. So it helps me digest the information better. And I want to give you a fun fact before we move forward. The underlying LLM that Damien just demonstrated, with the researcher tool, uses the same underlying LLM. All right, so with that, we'll keep moving. So how does it work? As I mentioned before, it uses advanced reasoning to connect information from across your organization. So all us lawyers tend to use emails for all our good stuff. So it reasons over emails, files, chats, trusted web sources. So you could give it a URL. Instead of simply searching and giving you the response, it synthesizes and curates insights, giving you a very comprehensive view rather than isolated facts. This deep reasoning is what, in my opinion, why researcher stands out, especially for legal workflows where context and accuracy is critical. It pulls relevant data and represents it in a structured way to give us a head start. So as you can see here, and as Ashok had demonstrated, you can follow along with how it's reasoning over your data. I also think it's super relevant because it helps me see where I went wrong with my prompt so that I can use a secondary prompt to adjust the content, or I could go restructure and start all over again, or give it the right resources this time around. With that, we'll keep going. And so, as I mentioned before, it's accessible everywhere you work, whether you're on a desktop, mobile, or within a Microsoft 365 app. This image shows how seamlessly you can access Researcher. And now we'll talk a little bit about the data sources. So as Damien had also mentioned, grounding on good sources is critical. You have to give it the right data. So with M365 Researcher, you can draw from multiple data sources to get the most complete and comprehensive response. It can use the enterprise data that you're authorized to access based on your organization's content settings and permissions. You can also use trusted web content to enrich the response. And then it also allows you to connect to approved third-party systems that you have a license to. And this allows you to reason across all those sources to ensure that you have a well-informed response. So how can you use the researcher agent in your workflow? So this is more of Maha's perspective, and obviously you can come up with more use case scenarios. So I use it for contract analysis. It compares different contracts against different playbooks, supporting negotiations that have been going on in emails. You can use it now in Word, which I love. I know all of us lawyers love to work out of Microsoft Word, so now it's in Word. And I have a hint here for all of you. It will only get better, I promise. Regulatory research. So it helps you prepare for, like do updates to different regulations, look at how they compare with each other. So just last week, I asked it to compare the requirements between EU Data Act and GDPR in a format, in a table of format, to help me digest the differences between the two acts and see where the compliance requirements may differ for cloud service providers. Then it also helps with document and clause discovery. So you can ask it to rewrite certain clauses for you to be more, plaintiff friendly, or you want it to be more heavy on, be better for a licensor as opposed to a licensee. So it helps you kind of tailor that. And then it helps you with legal research and then matter summaries, as I've mentioned before. And with that, I will ask Farah to take it away.
Awesome. Thanks, Maha. So from here, I'll focus on how Researcher Agent fits into legal workflows, what it does well, when to use it, and how to really get the best results. So let's start with the big question. How is Researcher different than Copilot Chat? Think of Copilot as your quick helper. It's fantastic for fast tasks like drafting an email, summarizing a short document, or pulling a quick definition. It's built for speed and simplicity. Researcher, on the other hand, is your deep dive partner. It's designed for complexity. So instead of giving you a quick answer, it can spend 10 to 30 minutes really reasoning across your designated sources, internal policies, contracts, regulatory frameworks, even trusted web content to produce a comprehensive contextual report. Here's an example. If you ask Copilot to summarize GDPR, you'll get a neat paragraph. If you ask Researcher, analyze GDPR implications, you'll get a structured report with sections for executive summary, key risks, and recommendations, plus citations to your internal playbooks and external regulations. So if Copilot is your sprinter, fast, efficient, great for short bursts, Researcher is your marathon runner. It's built for endurance and depth, giving you insights you can act on. Next slide, please. So let's dive into when Researcher really shines. Think of it as your go-to tool for complex, high-value work where precision and depth matters. So, for example, multi-source synthesis and structured drafts. So imagine you're tasked with a regulatory scan across multiple jurisdictions. Instead of manually pulling together data from 5 different sources, Researcher can consolidate everything, internal policies, case law, into a single structured draft. It's not just a summary, it's a well-organized document that gives you a head start on your analysis. Comprehensive detailed output. So Researcher doesn't stop at bullet points, it really can produce structured reports with sections and analysis. In-depth research across multiple sources. So legal work often spans contracts, regulations, internal playbooks. Researcher can pull insights from all these sources and weave them into a coherent narrative. And lastly, first draft acceleration. If you need a solid starting point for a memo or a playbook, Researcher is going to be your favorite tool. Instead of staring at a blank page, you get a structured draft that you can refine in Word or PowerPoint. So Researcher can really do the heavy lifting for you. So now let's talk about when not to use Researcher. The flip side, when Researcher is not the right tool. This is just as important because using the wrong tool can really slow you down. So when not to use Researcher for quick answers or simple tasks. If you just need to summarize a short email, Researcher is likely overkill. For example, if you need a quick response to what is GDPR, Copilot chat is just faster and lighter to use. Tasks requiring speed over depth. So if you're under time pressure, say you need to send an urgent update, Skip researcher. It's really, again, designed for depth, not speed. Again, Copilot is your sprinter and researcher is your marathon runner. Simple drafting needs. So if you need a short email draft or a quick paragraph for a slide, again, Copilot Chat is going to be your best bet. Researcher will end up giving you a full report when all you really needed was 2 sentences. Also, lastly, heavy quantitative analysis. So researcher really isn't your spreadsheet buddy. If you need to crunch numbers, run financial models, or do statistical analysis, use the specialized tools first, like Excel or Power BI, whatever fits, and then bring those insights back into researcher for narrative synthesis. So that's where researcher really shines, like turning raw data into a compelling story. Another thing to kind of consider is researcher only works with what you have, and it can't invent missing information. So your sources, if your sources are incomplete, or if you don't have access to the right databases, the output will reflect that. So before you start, make sure you have the data that you need. Next slide, please. So a quick example here is using researcher to convert a document into a clean, structured table. It doesn't just reformat, it adds clarity, highlights gaps, and gives a report that could be shared with the team. This is the kind of value researcher brings, turning complexity into something actionable. Next slide. So how do you get the best out of researcher? Think of this as setting the stage for success, because the quality of your prompt determines the quality of your output. So first, set the role. Start by telling researcher who you are. For example, you are a privacy analyst. Why does this matter? Because it frames a perspective your output will reflect in the priorities of that role. So if you're a compliance officer, the report will lean towards regulatory risks. If you're a product counsel, it will focus on contractual and IP issues. Then pick your sources wisely. More isn't always better. Too many sources can really slow things down and clutter your results. So choose the most relevant ones. Your internal playbooks, key regulations, trusted external references. Think quality over quantity. Next, give some guiding principles. So this is where you kind of set the tone. For example, focus on legal accuracy and actionable recommendations. The clearer your principles, the more useful your output. And then lastly, specify the output format you'd like. Do you want bullet points? Do you want paragraphs? Do you want a 3-page memo or an executive summary? Tell researcher upfront. This saves you time and avoids unnecessary edits later. And remember, you're in control. So the more precise your prompts, the better the output. So next slide, please. So one example is for contracts. You are a commercial contracts counsel. Look at the sources like internal playbooks, clause libraries, negotiation logs. The task, analyze third-party contracts and flag risks and suggest fallback positions. The output here is having a clear structured report. And this is where a researcher can really save hours of manual review. So that's really the power of researcher, helping us work smarter and faster. But of course, with innovation comes responsibility. So Tony is going to take us through the legal risk side, what to keep in mind and how to mitigate risks.
Hey, everybody. Good afternoon, good morning, and I don't know, maybe good evening, possibly, to everyone joining us online. And thanks again for spending part of your day with us. My name is Tony Beasley. I'm a senior corporate counsel at Microsoft. I serve in a function very similar to Farah, Maha. Thank you very much for the demo and the discussion of researcher. I'm on their team, and one of the products I principally support as a lawyer is called Copilot Studio. For those of you not familiar, it's a platform that enables enterprises to build, customize, and deploy AI-powered agents. Oftentimes, it's a conversational experience like a chatbot that's tailored to your specific needs. So speaking of agents, ever since Microsoft started offering AI-powered copilots a couple of years ago, Our legal department, I'm sure similar to many of you watching this right now, have grappled with a lot of novel questions about privacy, IP, ethics, and other topics that stem from the transformative, powerful capabilities of large language models. A lot of that, similar to what Damien was talking about in his excellent presentation a few minutes ago. The next evolution, I think, of these copilots has been the ability to really delegate tasks to autonomous agents. So in this portion of the talk, I want to share with you some of the legal issues that we've seen recur with autonomous agentic AI and how Microsoft has, how we've been thinking about some of them as we develop and as we deploy some of these types of products. So just setting the table a little bit, what am I talking about with autonomous agentic AI? Unlike a typical generative AI experience, like interacting kind of one-on-one with an LLM, with a user prompt, and you get a text or an image or some other kind of output as a result, autonomous agentic AI can, depending on how much authority it's given, make decisions and perform multi-step tasks on your behalf. And again, depending on how much scope of control it is afforded, it can often do this across different software, different services, with varying degrees of human intervention at each step. So here on the slide that's shown here, I want to start off by kind of giving you an example. This may or may not be a fanciful example. You might hear a little bit more about this soon, but let's say there's a thing called a sales outreach agent whose function is to alleviate some of the monotony of sales-related tasks that your salespeople are doing at your enterprise. It might be able to read incoming emails, extract data from data sources from perhaps your CRM, customer relationship management system. Maybe it can even update the CRM. And then maybe it can take other actions like sending a follow-up message to the external customer, and then maybe even schedule a follow-up meeting all on its own based on some initial instructions that you provided it. This leap from automation to autonomy creates, of course, enormous potential for efficiency, but it introduces new legal and operational risks. And I know that the legal professionals on this call have probably already spotted a bunch of issues with this workflow example, and just kind of going through them one by one. So if the agent is accessing email, how was it delegated the authority to even read the email inbox in the first place? Was it through an actual email address or an identity that the agent was assigned, or was it delegated the ability to read the inbox of the salesperson themselves? And how wide of an email access does it have? Is that access appropriately scoped? Is employee privacy taken into consideration? Now you go to the next row. It's accessing a CRM. That's great. Well, then there's a scoping issue there, because is it accessing everything across your entire organization? Or maybe something smaller, like a particular sales team in a particular region, or a security group, or maybe just even an individual salesperson. Can that access be revoked by an individual, by an IT admin, and how? And then what kind of CRM are we even talking about here? Is it your company's internal bespoke CRM, or is it something that your salespeople have individual subscriptions and licenses to? And where the reading and writing is done, how is that done? Is it via API? How does the agent get access to use that API? And so now we're getting to some really saucy capabilities on the third row. It can actually write emails and actually start communicating with people. Well, what is going on there? What does the email say that the agent is writing? How is the agent identified to the external customer? Is it plugged into your company's database of opt-outs and able to respect those preferences? Or have you even formulated a separate basis to send a communication, depending on where you are and depending on what the laws are? And how is the agent able to even handle the logistics of your customers opting out and unsubscribing if necessary? And finally, it's going to schedule a meeting. Great. So there's a little back and forth with your customer, and the agent is going to take kind of a heavy-handed action of actually going and sending a calendar invite. Many of the same issues here. How is access to the calendar granted? How is that access scoped? And then this kind of gets to like our overarching question with agents, which is, when should the human come back in the loop? Should the agent even be doing this in the first place? So let's go to the next slide, please. So the sales agent, that was sort of a specific grounded exercise to show how these issues might arise. And now I'll back out a little bit and give you a little bit of perhaps my own theory as to why autonomous agentic AI is actually different from a legal risk perspective. So these systems carry all the usual risks of generative AI models because of the nature of everything Damien was talking about. The black box, which may not be so much of a concern if you if you follow his reasoning, but the agents add unique challenges because, as the name implies, they possess agency and they exercise independent action. A helpful way to illustrate this dichotomy is simply to state that generative AI responds while agentic AI acts. So this higher level of operational autonomy means that a mistake by an AI agent isn't merely a wrong answer or some potentially incorrect information, but it could be heightened to result in an incorrect action. And as we are well aware, as legal and risk responsible professionals, actions are things that carry real consequences. So along with our partners across Microsoft, including the Office of Responsible AI, we tend to bucketize the risk factors associated with the agentic autonomous AI in the following ways. The first one is cascading errors. Stated simply, that means if you make a mistake in one part of the chain, it might propagate and create further mistakes that are more widespread down the line. Unpredictable autonomy is the next big bucket, which basically means with limited oversight, it might act in ways that you can't really predict. And then multi-agent complexity, if there's multiple agents that are interacting with each other, triggering each other based on inputs, the risks can be amplified in that scenario as well. One agent's error might then misinform another agent, and then they get together, they put their agent heads together, and they come up with all kinds of wrong things. So that's another area of complexity. We always need to exercise discretion and diligence with any service, especially anything that has the capability of generating information with an LLM. But these factors are maybe why you need to be a little bit extra diligent with the autonomous AI. If we think about the sales agent that we were talking about from the previous slide, imagine, for example, a scenario in which the agent has received an email from a customer and it has misinterpreted it, maybe in a way to ascribe interest to that customer, when in fact they want it to be left alone. And based on this misinterpretation, a CRM record is updated incorrectly, and then other actions then flow from that record, maybe by additional agents with delegated authority by other members of your sales team. And that customer starts getting additional unwanted emails, Outlook invites, or what have you. So in that scenario, that initial error has now cascaded across multiple data sources and actions in perhaps a way that wouldn't have happened if there was maybe more human oversight in the first place, or somehow a flow that was tested a little bit better or developed to have maybe a lower propensity for that mistake in the first place. Let's go to the next slide, please. So with all that table setting, with those risk buckets in mind, I wanted to talk a little bit more about some specific issues that we've noticed can potentially come up with autonomous agentic AI. And hopefully this is useful as you start looking at how agents are developed or deployed at your own organization. Again, first overarching big one, human oversight and accountability. You have to look at, who's in charge of what. If there's a lack of oversight, this can potentially elevate your susceptibility to liability if an agent causes harm to someone outside the system. So you do need a clear accountability framework. For example, who's responsible if the agent messes something up? The best practice is to maintain human in the loop for higher impact actions and ensure users can intervene or override agent decisions when necessary. Data privacy and protection, always an issue with any product. And with agents, as we start, we need to start thinking about how to delegate those obligations. So this really falls into the bucket of a potential cascading error that we talked about from the previous slide. We need to be sure we know how the agent is collecting, using, storing personal or sensitive data, and where. And then, of course, agents, even when they're executing actions removed from what a human specifically instructed, they really have to avoid violating privacy commitments when they access things like emails, files, or other content that might be on your company intranet. Automated decision making / memory is a privacy adjacent topic. Agents tend to perform tasks or give us answers that are more relevant when they have more history and context about the user. This type of feature is often referred to as a memory. You do have to beware because the older and wiser the agent becomes over time, the more likely it might be that it's encroaching on things like, for example, Article 22 of the GDPR. So you need to look and see if the agent can use this information to autonomously make decisions with legal or significant effects on individuals. Think like credit approvals and things like that. And that kind of leads into the next thing, regulated and sensitive use cases. Agents that are used for things in highly regulated domains like healthcare or financial advice will, of course, warrant extra scrutiny. And if they perform tasks in these sensitive areas, like, for example, helping with a medical diagnosis, something like that, as good as they are, as good as kind of Damien alluded to, it might require compliance with sector-specific laws. If your organization is like ours, you might have a team that processes. You might have a team or a process that is specifically dedicated to evaluating sensitive uses, and it might need to go through those steps. Transparency and disclosure seems pretty straightforward, but we've seen a very wide spectrum of approaches out there. At Microsoft, we do feel quite strongly, and it's part of our responsible AI standard, that transparency is crucial. Agents should identify themselves as AI because if they're opaque, it will undermine user trust. And it might actually run afoul of emerging AI regulations in several jurisdictions and several states. IP, you need to be aware of what the agent is outputting, of course. There's always a risk that it might inadvertently include copyrighted material, for example. So however you're embedding the generative AI capabilities and agents, you need to be able to mitigate the regurgitation of that type of material. Contracts, terms of use. If you are in a position similar to how Microsoft finds itself often, if you're building an agent that might be used by external customers, got to update those user terms or documentation. You need to spell out the customer's responsibility to supervise the agent and possibly even add terms or limitations of liability for autonomous actions. And then last but not least, for our friends in HR and labor, if you have agents that are geared towards certain workplace functions, that will require further considerations, especially if you're in Europe, consultation with employee representatives like a works council. And there we've seen that control or configurability is really, really key. Being able to control what the agent does and doesn't do in certain jurisdictions is always helpful. Let's go to the next slide, please. The last thing I wanted to spend a little bit of time acknowledging is an emerging type of agent called a computer use agent. I've got an example up here on the screen. This is actually from Researcher, which now has computer use capabilities. What these are basically agents that are capable of going in through a virtual machine, interacting with a graphical interface like a human would. It can take natural language instructions and then perform the actions by seeing pixels on the screen and clicking around, inputting text across apps, and then by using these instructions, they're being deployed for tasks such as gathering data from multiple websites or performing research across enterprise and web applications. And in this example I put up, I used Research Agent yesterday to try to find some place to eat on my drive home from the office today. And as you can see in this snapshot, it has literally opened up a Google Maps window and started hunting around for me. So very cool, but very interesting app, very interesting legal implications because of how it works. You have to think about unauthorized risk. CUAs can interact with systems at scale, which means they might inadvertently violate things like the Computer Fraud and Abuse Act. So always confirm that your agent's actions are authorized through features like allow lists or similar things. Second is to respect automation codes. If you're familiar with robots.txt, that's a signal that basically is meant to prevent, crawling and similar actions. There's also a code of practice in Europe for automated systems, so beware of compliance with that. And then lastly, abuse prevention and anti-spam. CUAs can increase the risk of spam or accidental repeated actions, and potential mitigations you might think about here are implementation of submission or click limits and other safeguards that might prevent spam or unintended repeat actions. So with that, I just wanted to conclude briefly by acknowledging again, autonomous agentic AI can, I think, potentially transform how work gets done by automating certain types of tasks, but we do have to, as legal professionals, be developing and deploying them with eyes open to risks and frameworks in place to manage them. And if you take nothing else away from this, remember that these types of products, agentic AI, it builds the key legal concept you need to consider right into its name. It's agency. You are granting agency to what is at the end of the day a computer program. And as the principal, you are responsible for guiding and instructing the agent appropriately and fixing things if it messes up. So think about the best way to instruct, scope, test, make sure that there's a human in the loop at the appropriate time, and that will go a long ways towards ameliorating the additional risks of using autonomous agentic AI. So that's it for me. Thanks so much, everyone, for watching, and I'll hand it off to our friends at Korn Ferry.
You hear me?
Yes.
Loud and clear.
Yes.
Excellent. Good morning, good afternoon. Pleased to be with you. I'm going to kick it old school today. I'm not going to pull up slides. I'm simply going to share my thoughts and experiences around talent strategy and AI readiness, the new lawyer profile. So by way of introduction, my name is Cleo Kirkland. I lead Korn Ferry's North American Legal Center of Expertise. I am a recovering lawyer myself. I practiced commercial litigation in private practice for 6 years before moving into search about 16 years ago. And while I did not like practicing law myself, I love working with lawyers and with law firms. So go figure, the world works in mysterious ways. The practice at Korn Ferry, the legal practice, is pretty evenly split between law firm work, and that includes everything from lateral partner recruitment to C-suite mandates to managing partner succession processes, as well as in-house counsel, which tends to be focused on the CELA or the GC and his or her direct reports. We've also been doing some growing work for recruitment within the legal tech sector. In terms of context setting, I mean, you've heard a lot about this already. I do not need to tell this group that AI in the legal profession is not a future issue. It is reshaping the legal ecosystem right now. This transformation is well underway. And the pace of change is really antithetical to how most lawyers are comfortable operating, which is slow, cautious, precedent-driven, measure 3 times, cut once. I don't think it is too much to say that AI is the biggest disruptor our profession has ever seen. It is affecting every aspect of legal work, from basic document review to strategic decision making. I'll start with some general observations around talent in the profession and the implications of AI, and then get into specific implications both for in-house populations and for law firms. The legal profession is really fraught over this. It is keeping a lot of people up at night. Some they view AI as an existential threat that is coming for their livelihood. Others view it as the most powerful augmentation tool out there. I would argue that most lawyers naturally fall into the former bucket as opposed to the latter. Just a couple of data points. In 2024, McKinsey projected that generative AI could automate up to 44% of current legal tasks. And it's estimated that currently within the AmLaw 200, well over 60% of firms are using AI, and many now have firm-wide policies in place. In terms of the major areas of disruption, Damien touched on a few of these. Efficiency gains for more commodity type of work. So think of initial contract drafting, e-discovery, due diligence. Quality improvement for more sophisticated work, so AI tools can flag risks and mistakes that humans might miss. And then, as Damien mentioned, the access to justice element is substantial here. Low-cost automation can really expand the reach to what is a vast underserved client population. The cultural shift for the profession is really also hard to overstate. The traditional model of craftsmanship, hierarchy, precedent, judgment is clashing with a new model that is data-driven, that is tech-enabled and agile. When you think about the new lawyer success profile, it's really going to be that of a professional who can combine judgment, empathy, creativity, the relationship side of practice with data literacy and AI fluency. And whether you're an in-house counsel advising an organization or practicing at a firm advising many clients, your clients will increasingly expect you to balance these two things. So specifically turning to in-house populations for a moment, what are the talent implications of AI? For one, it really is changing the nature of their work. In-house teams are leveraging AI to manage high volume, low complexity work like NDA, compliance tasks, contract summaries. The result is a reduced need for large junior in-house counsel populations. This is typically where many young lawyers go after a few years in private practice when they determine law firm work is not for them. And many go there straight out of law school. So I do think there are going to be fewer and fewer of those roles available. And work that is sent outside to law firms is increasingly highly specialized or considered bet the company litigation or transactions. In-house counsel are also adapting their expectations of outside counsel. CLOs have a heightened expectation around transparency of AI use, including cost savings being passed through to them. Some sophisticated in-house teams are actually migrating their work to firms that they think are further along in the AI readiness curve, which may give the biggest, most profitable firms who are able to make these huge investments a meaningful advantage over others. There's also ethical and data implications around growing concern that some in-house counsel about how their outside counsel are feeding their confidential clients' data into their systems. And the next differentiator may not just be legal expertise, but AI governance maturity, questions around how data is secured, audited, and ethically used. All of this is impacting talent profiles for leading chief legal officers and their teams. In-house legal teams are increasingly hiring legal operations professionals, so folks who understand workflow automation, data scientists and legal engineers who can translate legal problems into technical solutions, and AI ethicists to guide responsible adoptions. The talent implications for law firms and private practice are arguably even more severe. In terms of the attorney population in law firms, so everything from associates to counsel to income partners to equity partners, the leverage model, the traditional partner-associate pyramid, is under considerable strain. AI is already performing much of the apprenticeship work that had typically been done by junior associates, so document review, first drafts, research. This is really only going to increase. The big questions for law firms include if AI does the junior work, how will young lawyers learn? And then another, I think, more interesting question is how will a firm create a robust enough pipeline of future partners if they're going to need far fewer associates? How do they build that pipeline up? Interestingly, law schools are beginning to adapt. They're teaching things like prompt engineering, AI ethics, and data-driven advocacy, which is certainly nothing I was taught when I went to law school a million years ago. The new law firm profile in private practice is technologically fluent, business-minded, and comfortable collaborating with non-lawyer specialists. In terms of the non-attorney population at law firms, where AI is having the biggest impact is a couple of places. First, I would call out the Chief Information Officer, Chief Technology Officer. This has historically been a somewhat overlooked role, often occupied by a lawyer who didn't love practicing, heavy emphasis on knowledge management. It really is increasingly central to firm strategies. This person is expected to be externally facing, agile, at the vanguard of AI integration. The fast follow approach, which most law firms adopt, is really to wait for best practices and adopt them rapidly. So this has caused a pretty significant churn within that chief technology officer, chief information officer seat within big law. Another place is the chief people officer, the chief talent officer. Historically, the focus was overwhelmingly on the attorney population, and now firms are recognizing the value and necessity of non-lawyer talent. I had a conversation recently with an AmLaw 25 leader who remarked that they weren't even sure they were going to be a law firm in 10 years, which is obviously a provocative thing to say, but I think it demonstrates just how much change and transformation many of these firms believe lies ahead. Within law firms, AI is creating demand for technologists and data experts to really live at the core of delivery, and innovation officers to drive adoption. These folks are now actively recruited by firms, reflecting a more multidisciplinary workforce. And it requires a different kind of legal talent, professional talent leader to ensure that population is as developed, retained, cared for as the attorney population. The final point I will make on law firms is just around law firm leadership. So in addition to the search work we do at Korn Ferry, we also facilitate law firms in selecting their new, whether it's a managing partner or CEO, the nomenclature varies depending on the firm. And this is essentially standing up a process by which equity partners can evaluate a subset of equity partners and select the next firm leader. We've been doing this work a long time, and the criteria can change depending on the firm and depending on market conditions, but generally the top of the list will include things like strategic vision, business development success, stakeholder management, collaboration, and increasingly technological fluency has been identified as a core competency. Partners are expecting their leaders to be comfortable driving digital transformation, not simply proving it. One of the more recent pieces of work we did with a firm, one of the key criteria was called technology savvy humanist, which I think means someone who can lead with both empathy and data insight. So all that to say, the talent implications of AI are vast. They are still unfolding. Both law firms and in-house departments are struggling with redefining career paths, balancing efficiency with development, building trust in technology. The profession is very uncomfortable right now. I think that's okay. Transformation rarely feels comfortable, especially for this conservative a population. And I do think in 10 years, the profession will look dramatically different from all sides. I think those who will thrive are those who really will embrace AI as a partner and not see it so much as the competition. Thanks so much.
Cleo, brilliant. Thank you Thank you for sharing your perspective. With that, Grant, should we close out? I know we have a couple of minutes. We have some departing sort of call to action and resources. Go ahead.
Absolutely. Thank you, Simona. And on behalf of Simona and I, I'd just like to thank our presenters, Damien and Cleo, as well as our Microsoft colleagues, Tony, Farah, Maha, and of course, Brian Willson. Today was a great exploration of AI in the legal industry in both theory and in practice. And we saw how with tools like Copilot, Chat, and Researcher Agent, an attorney can really boost productivity, research, and speed. Thank you all so much for attending and spending 90 minutes of your day with us today. We will be sharing this recording with you very shortly. So thanks again and have a great rest of your day.
Thanks, everyone. Bye-bye.